Hearing in the appeal of Mohamad Jiaved Ruhumatally against the state of another.
Mr. John Backus, Mr. Good morning. It occurs to the board that we would be greatly assisted if we could hear first from Mr. John Backus in relation to the elements of the offence of murder in the law of Mauritius, what it's necessary for the prosecution to prove in order to secure a conviction of the offence of murder, with particular reference to issues of intention, premeditation, and causation. And once we've heard you on that, we'd like to hear Mr. Ramine briefly in relation to that. We will then have a framework within which we can address the submissions that you're proposing to make.
My lords, I am James Ramden, UK Counsel, and I'm assisting Mr. Zaradin John Backus.
Mr. Ramdan, forgive me, I thought you were Mr. Juan Backus.
No, I'm the person in charge of the case, my lord. So, if I may start by saying, may I have your permission? May I have the leave to take the matter? I've just been somewhat a little bit unwell, but that should not put me in any difficulty.
I'm sorry to hear that. If at any point you want to take a short break, please say.
Thank you, my lord. There should be no problem with this. My lord, the first point that has been raised in this matter is unfairness more than anything else. The whole trial.
Yes, I understand, and we will come to that,
yes.
But we'd be grateful if you could start, please, by addressing us in relation to the elements the prosecution has to prove in order to secure a conviction for murder in Mauritius.
The prosecution has to prove, on the basis of the mens rea, actus reus, and the premeditation. This is something that they have to prove, which has not been proven to the satisfaction of the appellant. That's the main issue we have. But on the side, my lords, these are the other issues, that every aspect of this case has been so unfair. And that's his other elements we intend to prove this false on us, to show the unfairness. But on the other side, this is what they have to prove.
Well, I understand you'll be coming to your submissions in relation to the unfairness of the proceedings, yes, as you maintain. But before we address that, we need to have a legal framework within which to address these questions, and therefore we would be grateful if you could address us, please, in relation to the elements of the offence of murder in the law of Mauritius.
Yes, my lord, the elements basically, as I said, is the mens rea, the mind. What we are saying that our client, the appellant, did not intend at all to commit the murder of which he's been accused and has been found guilty of. That's the first element. And the facts are very clearly, briefly, which I'll come to it a bit, to expand on it, that their intention was simply planned to rob the bank.
Is an intention to kill a prerequisite of a conviction for murder in the law of Mauritius?
Yes, ma'am.
Thank you.
This has to be. But has not been, there was no such thing at all.
Is there a statutory provision to that effect, or is it a matter of common law? Where do we find that an intention to kill is part of?
Let me get that from my colleague here. That my lords and lady, the section 216 of the Criminal Code
Where do we find that?
581.
Sorry?
581.
582.
581. Thank you.
My lady.
In the electron bundle, you would have it in 582.
Yes, thank you.
So that builds on 215, which says homicide committed willfully is matched. So that's the intent element, is it?
Yes.
Well, forgive me, Mr. Ramdan. Does willfully mean with a specific intent, or does it simply mean by a deliberate, non-accidental act?
Well, my lord, the willful means intentionally intended the act, the purpose, and the result. So that is the basic of every criminality.
So if you commit an assault, what's the willful part? It's not...
Well, if you assault, obviously an intent is involved. If
Intent to commit the assault?
yes, you have to
Yes.
have an intent.
Yes.
Yes.
So you say that the effect of Article 216 read in conjunction with 215 is to require both an intention to kill and premeditation
Yes.
before there can be a conviction for murder. Is there a presumption of law in the law of Mauritius that a person intends the natural consequences of his act?
Well, presumption, my lord, on any matter of murder or manslaughter is based basically on inference and whatever. Presumption exists. Presumption, my lord, is a matter which exists in everywhere in the world, whether Mauritius or others, but presumption is based on the facts that give you that inference or the presumption. So the presumption generally, yes, the law does give you permission to presume, but presumption is based on the natural circumstances and facts that surrounded the case.
And where do we find the statutory provision creating a presumption of law that a person intends the natural consequences of his act? Where do we find that provision?
We don't have, Mauritius don't have this.
Where do we find the definition of that presumption? In what, is that a matter of common law, or where's the authority for it?
My lord, as I understand it, the presumption in Mauritius is based on some basic common practice. There isn't a particular common law as we have in UK, but they would have it based on the general practice as they go along. There's nowhere, as I understand it, is in writing.
Mr. Ramdoon, at page 282 of the record, in his summing up to the jury, the judge dealt with element number 5, intention to kill.
Yes.
And he said, finally, because it is so easy for somebody to do something and then to say subsequently that he did not intend to do it, the law stipulates that we can act on a reasonable assumption, namely that a person must be deemed, he must be taken to intend the natural consequences of his act.
Yes, yes, but that is the general assumption they make, my lord, in Mauritius. That's how they take it. But everything you say on the basis of assumption is based on the facts itself, the surrounding facts, the circumstances. But here we're saying that the assumption that has been made was wrong.
I understand that, but we'll come to that. But is it a presumption of law? The reason for asking this is that we did have a rule in this jurisdiction, in England and Wales, which was abolished many years ago by statute in 1967.
Yes, my lord. Yes.
To the similar effect about intending the natural consequences of your action. But that's why we need help in relation to this.
Yes. My lord, if I may ask my...
Yes.
Okay. So, my lord, as I understand it, in Mauritius, we don't have anything in writing, anything that they can guide themselves to that position.
So the judge then quotes from what I understand to be Encyclopedia Dallos, is that right?
Yes.
99 and 100.
Yes.
Paragraph.
Yes.
Translated at 1303.
My lord, so position in Mauritius is seek guidance from Dalloz, French law, seek guidance from British law, whatever is helpful, convenient to reach a proper justice point. So, yes.
What was the reference to the translation?
1303.
But is this a correct summary of the law the judge has given in his summing up here?
No.
No.
This,
What's incorrect about the law?
now the part, my lord, could you refer me to the part which you are referring to?
282, page 282
Of the record.
of the record.
That's fine.
I had rather taken it that you were agreeing with the legal principles as set out by the judge, but you're saying that factually they were misapplied. That's my understanding of what your submission was, but correct me if I'm wrong. Did the judge get the law right?
No.
Why not?
No. Well, the way the judge has approached the whole matter, Your Honor, my lord, was based mainly on a subjective view rather than an objective view. I cannot see that's the reason why we are here. We do not see anything here that, if particular area you tell us, because if in general, that's a fact. But if particular paragraph, we are happy to give our view of what it is, what it should be.
What's he got wrong at page 282, beginning at the top of the page?
No, what this one is it?
The sentence that we're particularly concerned with is the law will assume that he intended. So it's a legal presumption, not the judge's subjective interpretation.
Yes.
Do you say that's right or wrong?
Yeah. See, the point taken here, my lords and lady, is that in Mauritius, as I understand, there is no such law where it says the law will assume. That is the first paragraph, bottom line, second line up. The law will assume that he intended the natural consequence of his act, and therefore that he intended to kill the victim when he pointed a gun at him and shot him. So this is basically is wrong. The law, that law is not a law that exists.
So you're saying that there is no presumption of law in Mauritius,
But
that a
that's what.
person intends the natural consequences of his act?
Well, that's the situation in Mauritius, as I understand it.
I'm sorry, let me repeat the question. You are saying that there is no presumption of law in the law of Mauritius that a person intends the natural consequences of his act?
Yes, yes.
And Dalloz is simply referring to a presumption of fact. Is that right?
Yes.
It won't let me put the hearing bundle.
Thank you. Thank you. Now, can you help us in relation to premeditation?
Premeditation, exactly the situation as it exists here.
There is no requirement in the law of England and Wales. There is no requirement of premeditation
Yes, but
for a conviction of murder.
in Mauritius, they have some basic understanding of what they construe as premeditation. So, it's been,
Is it 582 in the hearing bundle?
217.
Yeah,
Yeah, the interpretation,
section
217.
582 of the hearing bundle.
Page 582. Interpretation of premeditation.
Yes. Should we hear from Mr. Thank you, Mr. Ramdoon. I think we'd like to hear on this point, if we may, from Mr. Aminet, please.
Thank you, my lady and my lord. My lord, the learned judge, in fact, referred to the elements of the offences of murder at page 1603. At page 1603.
Is this of the record or,
Yes.
or of the hearing bundle?
The record, I mean,
It's the hearing bundle.
277.
277, yeah.
Yes.
Where he listed all the elements which need to be proved by the prosecution, beyond reasonable doubt. And my lady and my lords will see where he mentioned about the need to prove that there was an assault on the deceased, that the assault must have been an act which was carried out willfully. Also, it must be shown that the accused was the person who committed the assault or participated jointly if he is prosecuted as a courter, the concept of the courtship. Fourthly, that is the causation issue. It must be established that the death of the victim resulted from the assault. Fifthly, that the accused, the defendant, had the intention to kill the victim. And finally, lastly, that there was the element of premeditation. And then he went on to explain the different elements of the offense of murder, and by referring to the facts of the case as well. Now, to answer the question put by the board with regard to the extract that the learned judge referred at page 282 or 1608 of the record, I will, in fact, and to answer the question of your lordship, whether there is a presumption.
Before you get to that, the intention to kill,
Yes.
does that come from the requirement of willfulness, or is it to come from somewhere else? Is it in the statute, or?
It is. I mean, our criminal offence of murder is codified, the sections which have been referred.
Yes.
And the interpretation of the elements of the offense are, in fact, the source of our criminal law is the French law, the French principle. So our courts have been interpreting these elements of the offenses by referring to Dalloz, to Garçon, to the French jurisprudence. This is where we derive the source of our section of 216 and what follows. So every time, as your lordship, your lady, must have noticed, we have included several extracts of the French principle with the relevant translation. So this is where we obtain guidance as to the different elements of the offense. And I would wish to refer your lordship to one of the authorities we've referred to on page 674. That could assist your lordship in understanding about the issue about presumption.
That's 674, the record.
674 electronic bundle.
It's in French. Is there a translation?
It's in French, and we have the equivalent translation.
Where is that?
At page 1313, my lady and my lord. So, my lady and my lord, I referred to that document. You will see at note 64, which is at the bottom.
1313, note 64.
Yes. So basically what it says that for a case and an offense of manslaughter, where somebody is prosecuted for manslaughter, in fact, the element of premeditation is an aggravated factor, coupled with the offense of manslaughter.
So what's an aggravating factor, sorry?
The
premeditation.
Premeditation, in fact, is only an aggravated factor which makes the offense of manslaughter more serious one.
Makes it into murder.
Yeah.
Right. So it's aggravating in that sense.
Yes.
It's a constituent element of the offense of murder.
Yeah.
But it's an aggravation of manslaughter.
If it's manslaughter, there's no need for the prosecution to prove premeditation.
Sorry, you said note 64 on page 1313.
That's the French version, and
No, that's the English version. But it
at the top
starts
of the page.
evidence, assessing intent.
Yes.
Where? Sorry, is that what you're referring to?
This is what I'm referring, my lady. You're right.
Okay.
Thank you. So what it says that evidence. What evidence? How do you actually prove that there was an intention to kill on the part of the defendant? It says, however, assessing intent is inherently challenging as it delves into the internal forum and escapes obvious external manifestations. Now, basically, that extract would, in fact, show that in order to prove intention to kill, very often the prosecution need to rely on circumstantial evidence. In fact, despite in the French text the word presumption is used, but it's not equivalent like in the English presumption as we know.
So it's inferences.
It's inferences, circumstantial evidence. So, for example, at note 65, I'm reading the French text where it says raisonnement par induction, recours aux présomptions. Il est des principes qui, face à l'incertitude, les recours aux présomptions s'imposent. C'est donc par un raisonnement inductif que le plus souvent l'intention établie sous forme d'une démarche méthodique en quête d'indices complémentaires et convergents. Elle exploite doublement la présomption. So, of course, in an appropriate case where there is sufficient evidence, there's direct evidence in order to prove intention, that would be straightforward. But in many cases, in the absence of direct evidence, the prosecution has and the whole system of law would be entitled to rely on presumptions as well to prove intention to kill.
And these extracts, are they textbook guidance or are they law?
They are guided. I mean, these authorities in France, they are used on a regular basis.
Authorities from cases. Sorry, I just don't.
Yes,
yeah,
I mean the learned author Garot, Garçon, Dalloz, they explain like. May I be allowed, for example, Smith and Hogan in UK, for example, learned authors. And of course, they do refer to case law, judgment as well, to explain the different concepts. And our criminal code, the source of our criminal code, is based on the French criminal code, Code pénal français. So we derive guidance from the French authors.
Is there a Mauritius edition of Dalloz?
No, my lord. We use the French text. There's nothing like one for Mauritius specifically.
Thank you.
Yeah.
Am I right in thinking that the classification of murder in French law is different from that of Mauritius, in that there are other categories of offence, assassination, for example?
Assassination, in fact, is murder. Assassination, assassinat is equivalent to murder. Manslaughter is equivalent to murder. So, in France, if someone is prosecuted for murder, that is, it is all the elements except the premeditation. And if someone is prosecuted for assassinat, then you need to prove the element of premeditation. That's the difference.
But does that classification apply in Mauritius?
It does.
So what are we concerned with in this case? This appellant was convicted of assassination or murder?
Assassination.
Because there was premeditation as well?
Because there was premeditation and intention to kill as well.
Yes. Thank you.
Forgive me, Mr. Director, I wonder if we could strip this right back to basics. Article 215 says that homicide committed willfully is manslaughter. The judge in his directions to the jury, page 278 of the record, line 10, explained that willfully meant simply a deliberate act.
Yes.
A voluntary and deliberate act as opposed to an accident. So pausing there, speaking for myself, it would seem to me that manslaughter in the law of Mauritius requires a deliberate act, which in fact results in death, but does not require an intent to cause death. Murder, on the other hand, is defined in Article 216 as requiring premeditation, but it appears that in addition, drawing upon French law, it's established that it also requires a specific intention to kill. Now, have I correctly understood the distinction between the two crimes?
My lord, slightly, not exactly the way your lordship has stated, has tried to distinguish between manslaughter and murder. For the offense of manslaughter, my lord, it is important for the prosecution to prove that the defendant had the intention to kill, specifically that he wanted to kill somebody.
Where do we draw that from? And may I ask, what yes. crime is committed under Mauritius law by someone who does intend to assault, intends, for example, to punch the victim, but does not intend to kill, but does in fact kill? The situation often referred to inaccurately as the one-punch manslaughter, a punch which is not intended or indeed expected to cause any very serious injury, but in fact the victim falls backwards, strikes his head, and dies. What crime does that man commit in Mauritius?
It would be possibly a crime in the criminal code for wounds and blows causing death without intention to kill.
Sorry, I didn't hear.
It would be the example given by my lord.
Yeah.
Is that it would be a case, a charge of wounds and blows causing death, willfully inflicting wounds and blows causing death without intention to kill.
I mean, is the law correctly summarised by the judge at page 289, where he goes through the various possible verdicts the jury may bring in, starting with manslaughter, which he says if you find intent but no premeditation, manslaughter, then it could be offence of assault with premeditation causing death but without intention to kill, and so on. Is that a correct summary?
Yes, to answer a question of your lordships in his summing up, maybe to assist, to assist and to enlighten the board with regard to the question put by my lord Horod, your lordship, your lady, will see where the judge at page 209 of the record, at the end, he explained to the jury about the different options which...
289, I think.
289, different options which were open to them should they not be satisfied with the offence of murder. So, my lady and my lord will say, first, says that the lesser charge of manslaughter, that is, if they were not happy, they were not satisfied that the evidence which we put before them satisfy all the elements, that is, including the premeditation aspect, then they should consider whether there was sufficient evidence to find him guilty on manslaughter. And then he went on to say the second lesser offence at line 20 that you can find is the offence of assault with premeditation causing death without intention to kill. This is what I just said earlier. And then he went on to say that if you find that the accused parties acted with premeditation but that they did not intend to kill but only cause injury, even if it is a serious injury...
Sorry, if I could, just before we move on from the second lesser offence, the premeditation there is what? That the accused parties acted with premeditation. Is that premeditation to commit an assault, or is it premeditation to do something else?
Yes, the assault.
Assault. So, but premeditation... Yeah, so they both intended to commit an assault and premeditated that intention.
Yeah.
Is that?
Yeah. The act of causing harm must have been intended willfully, but there was no intention to cause death. But nevertheless, the victim died as a result of his injuries.
Does the second lesser offence also have a mental element of intention?
Yes.
It does. Right.
Intention to kill.
No, assault. Intention to
So GBH, for example.
Yes. Intention to assault.
Yeah.
I mean, it's a very small point, but that isn't part of the direction he gave. It should have been that the accused parties acted with a premeditated intention to commit an assault, for instance.
With regard to the lesser offence?
Yes, with regard to the lesser offence.
With regard to the lesser offence, he says, in fact, here that...
but only, yes.
Number two.
Yeah.
Number two, the second lesser offence that you can find, the offence of assault with premeditation.
Yeah, okay, I accept that, absolutely.
So, and then he went on to explain the third one was wounds and blows causing death without premeditation and without intention to kill. So he listed a series of offences, less serious offences, for which they could have found him guilty if they were not satisfied with the different elements which had to be proved with regard to murder. So this is to answer the question of your lordship, but I was explaining that French text I referred, that is on the issue about presumptions. It's not presumptions as we know it in the English law. It's rather inferences which are made by the court. In other words, circumstantial evidence. So this is on the issue of intention. I don't know whether I've explained to your lady and your lordship sufficiently on that point, or maybe you would wish me to clarify further on these issues before I move on to premeditation.
On the presumption, is it simply that one is entitled to draw implications, the implication that a person intended the natural consequences of his acts, or is it a rule of law that you must draw such consequences?
There's no rule of law that there's a presumption that you must infer. It's always a question of facts. Premeditation has nothing to do with intention. They are two separate issues.
I'm speaking now about the intention, about intention to kill.
Yes, first, if you look at the case law we've cited in our bundle of authorities, the prosecution must prove that he has made up his mind to kill the victim. After he has made up his mind to kill the victim, there must be some time, a cooling off period, must not have been labored under any sort of pressure, where he think coolly and calmly, and then he committed the act.
Yes.
So
that goes to premeditation.
That goes to premeditation.
My question relates to intention to kill and how the presumption operates in relation to intention to kill.
It would be circumstantial evidence. If there is sufficient circumstantial on which the jury might infer that the accused had the intention to kill, that would be acceptable.
But it's a matter of fact, not a rule of law.
It's a matter of fact.
Thank you. And I think you...
And my lady and my lord, if to assist further on this issue, in our printed case, as from paragraph 52, we explain exactly the issues been raised by my lady and my lord. The board will see at paragraph 53, we start with the actus reus, and then the point raised, that is the mention of the intention to kill, and we referred to the French text with relevant translation of the French text to explain exactly what is required under this element, that is intention to kill. And then we move on, the board will see at paragraph 66 what premeditation is all about. And we referred again to the cases decided in Mauritius, and most of these cases decided in Mauritius, a reference is made to the French text with appropriate, but we also...
I'm so sorry to interrupt, but Garçon, is that a case or is it again
it's
like Smith and Hogan?
It's a textbook.
A textbook. So these aren't authorities, they're guidance.
Yes, they are guidance like a textbook, yeah. They're all about principles, doctrines on this issue. And we even referred to the issue of premeditation as to other jurisdictions like the US and South Africa as well. What amount to premeditation? It's almost universal, the issue of premeditation. If you look at the case of the principle, it's the same. It's a bit more complicated in the sense that in the UK you have intention to kill, that is sufficient. You include both in that element. Whereas the French law, it's like in addition to the intention to kill, there must be premeditation.
Thank you.
Thank you, my lord.
Thank you very much. Well, Mr. Ramdoon, that's been of assistance, and we're grateful to both counsel. We would now like to hear you, please, in particular in relation to the questions of intention to kill and premeditation in relation to this particular offence.
My lord, would the lordship want me to go straight into those, or should we have a base of facts of the case so that you would have an idea as to what happened, and then we come back as necessary based on the facts whether there was an intention or no intention or premeditation?
We have thoroughly read the papers. We're very familiar with, we think, with the facts of the case.
Yes, my lord.
So it's a matter for you as to how you develop the point.
So you would like me to go specifically on the facts, whether our client intended, so go in the intention direct. Is that what your lordship wants me to?
You don't need to introduce the factual background because we're familiar with it.
My lord, I was going to introduce the facts, very basic, and that basic would be to directly infer or make you, the board, understand some generality which is not straightforward. And if that can be of help, because there are other issues which has come in the matter which is not very clear. It hasn't come through the case itself. It doesn't come out straight. And I was hoping if the board allows me to go just very quickly, sweepingly.
Yes, very well. But very well, but bear in mind that the matters in which we're particularly interested in hearing from you are in relation to intention and premeditation and indeed causation.
I have that very much in mind.
Thank you.
My lord. My lord, the reason I said that, I would start by saying the very basic fact of this case. The case started where the appellant was actually invited by a man called Vinison, the employee of the bank, who knew literally everything about the bank, how to get in, how to get out, what to steal, what not to do. And he therefore got this appellant through his relative or friend, and he agreed to take at least £50% of the loot. And next to it was he assisted this appellant with 3,000 rupees to buy a bar, which he would use to prevent the door was linking with the vault to open. Now, next thing he did, he told the man, the appellant, how to go about it. He gave it a code name, Leo. And he also said that, look, in the vault there will be only a woman and possibly replaced by a man. And he made everything arranged in such a way that the appellant could easily access the vault and get out with the loot. He also mentioned how he was going to drop a coin to give the signal for them to move about. But he said, this is for the part of intention. He said that they should not cause any injury to the man who is the security guard of the vault.
Why did he buy 2 swords and bring a knife to the event then?
My lord, I do understand he had, I believe, not 2, but 1 dagger, I believe.
Yeah, he brought a dagger, but he had at an earlier stage bought 2 swords.
Well, I'm not sure on that, my lord. You see, my lord, I don't have a view of that, but as your lordship will say that that was never used. And that was behind that was a instruction. Now, coming to this, basically, that's a story of how the whole robbery was carried out. There wasn't anything beyond from the point of view of the appellant. But obviously the story...
Well, he recruited people to help carry it out.
My lord, yes, but there's a very important factor to note, that this man, Vinesan, who is an employee, who is a mastermind, he asked his cousin to go looking for somebody. He found somebody called Azon. Azon got Appellant, and Appellant then found some other people because they realized one man could not, or two men could not do the robbery. So that's how it came about, he employing, engaging, or using these people. But that was, if you're to carry out a robbery, is a very normal consequence. So that's the basic facts of the appellant. Obviously, what went wrong and what has happened, we have to go into. Then comes the intention, what the act took place, the circumstances that prevail at the material time, and that I am happy to enlarge to the highest level. My submission on this would be, my lord, that the most important factor I want to submit is that he abided by what the mastermind Vinesan did say, and he had it all the time in his mind not to cause injury. And his intention was to do exactly what Vinesan, the employee of the bank, told him to do. So if we come back to the action, if the board wants me to go into the action straight as to what really happened and how intention was developed, or there was, my lords and lady, we would say that appellant was that's very important, the fact, we know the fact, the coin was dropped to enable the three guys to go to the vault. To reach the vault, our appellant guy has to block the door to stop people from other side of the room or apartments, as a division, whatever it was, to stop them from coming to the vault in case there's a screaming, shouting, or asking for help. So he came immediately to the door to do that act, which he took, which we have to look into it very seriously. The time he took to block that door, as per the advice of the employee Vinesan, he must have taken quite a bit of time. And he was there. After that, he moved past through the door and saw that the two other confederates were busy doing whatever. According to the facts, he did not know anything what they were doing, not doing. He did not know. That's the facts, I believe.
Can I just see that by reference to the plan? A plan was sent through to us, and it shows a control room with a door leading into a corridor.
Sorry, what page?
And was that the door that was being...
Which page?
Oh, it's a separate, it was a separate document. It was a separate electronic document.
Sorry, apologies.
Yes,
and is the door that was blocked the door from the control room into the corridor?
Yeah, my lord, this is how I understand it.
Well, I want to know what the exact position is.
Yes, my lord, that would be very helpful. We have the plan in that, what page? My lord, would you have the plan in front of
I've
you?
got it, yes.
Oh, okay.
Yes.
Okay, my lord, I was very sure. So if you look at the plan, as I understand it, the appellant has, with his confederates, had to walk through. You see, my lord, you will see kind of the sign of the staircases.
Sorry?
You see the sign of staircases, the drawing.
Yes, I see, and I assume that those are the staircases he came up.
Yes.
The appellant came up,
So,
and he gets into the corridor, and
Yes.
then there's a control room door.
so the corridor. Yeah. Yeah.
It's loaded, it's downloaded.
Yes, so there's a corridor. Yes, my lord, just next to the drawing of the staircase, you would see the sign of door going into control room.
Yes?
Yes?
Yeah.
That's the door he had to block. And he
Nobody was in the control room then, is that right?
well, I have no information that there was or there wasn't. But that is the door he had to block, and then he come out of the corridor and move further. If you look at the vault room, the solid line in front, there is a door there. That's where he goes inside the vault.
Okay.
Can we say that, my lord? When you walk into that corridor that we say where he blocked the door, he walked further about maybe 2 meters or 3, I don't have an idea of it, and then he goes through that door into the vault. And immediately he enters that door, there is a table, a desk. Next to the desk was the body lying, and the two confederates were busy with whatever they were
But he
doing.
was, first of all, filling up bags containing cash. And did he go into the vault and then to the back of the vault and fill up the bags at the back of the vault?
Yes, my lord. So that's very important to understand that. So he went right inside, through the door, he picks his bag around there, fine, and goes straight to the end, towards the end of that room where the money was stacked.
And is there any division between the area in which the desk is and the area in which the money is kept?
No, my lord.
So it's all open to see?
No, so that so far my instruction is that there was no division of any kind. He went straight, and the body was very much at the beginning of the what we say a wall there, and the desk was against the wall, and the money was towards the end of the wall. So all the stack of money was there. That's how I understand it.
And can I just ask, the only evidence about all of this came from his two witness statements, the 14th and 16th of March statements.
Yes, my lady.
Neither of the other co-defendants gave evidence.
Yes, my lady.
So we can read exactly what he says about it on 728 onwards.
Yes.
Yeah.
It appears, Mr. Ramdan, from the second of those statements at page 2055, that on the appellant's account, when he entered the vault, Mr. Logès was on his chair, being held by Backy, with Steve also leaning over him. The appellant says he fills up bags with banknotes, but when he then moves towards Mr. Logès by this stage has been put on the floor, face down, bound hand and foot, etc. I think you were suggesting that when the appellant entered the vault room, Mr. Logès was already on the floor, but that's not the appellant's account, which, as my lady says, is all we have as an account of events.
What's the point is?
If you're looking in the record, it's 729.
Yes. My lady and my lords, what I understand, that when he went, probably he had a glimpse of what happened between the two confederates and him and Laz as a victim. That's what I understand. But what the information given here, I am not sure whether it happened when he was going to first entering, and because as you understand the corridor, you have the door, and you have the other door with the vault, and whether Lazarus was there and standing or something, I can't understand it, but he might have viewed the victim being held. And that could be.
It's not a question of might have viewed. He did. He said, I saw him. I saw that Baki had grabbed Mr. Lajes by his neck on his chair with his left hand. There's no supposition about it. And then he remains, in effect, in the same room whilst Mr. Lajes is tied, bags are put on top of him, and we don't know at what stage his nose was broken.
Although he does say he didn't notice what Steve was doing.
Yes, here, my lords, I cannot give a very clear explanation, but I could say that overall whether there was a mix-up of what happened before and after, I cannot say, but his most consistent explanation has been that he blocked the door and went in the vault. He saw the body lying. He went straight to pick the money. That is his consistent information we got.
Well, where? Where did you get it? Because the only evidence, he didn't give evidence at trial.
No, the statement he made.
It's just the two statements.
Yes, that's right.
So we have to proceed on those, don't we? We
Yes.
can't go on some other account.
No. So that's a statement, but why I say that, my lady, there is some kind of misunderstanding here. He made quite a number of statements, which obviously is not, because this only were accepted, admitted, only the limited one, which
These
is
two,
here.
yeah.
Yeah, so maybe our knowledge is mixing up with the other documents. But I take it this is what he said, and that is where we have to rely on.
Yeah.
Yes, my lords. Now, we understand that what happened, basically, of the situation. Now, our case is that the intent to kill. He might have seen what was happening, but he never thought, this is his, again, what I understand, that the victim should be killed or cause any injury. And this, I haven't seen that Appellant in any way has done any of those. The basic facts, we understand it, is gone into the vault, took all the money, and when he was all cleared with the 3 bags in his hand, turning around to walk out, his confederates, one of them, said, could you tie the face of the victim? And
he didn't. The statement his statement is, Baki or Steve, he told me to tie the mouth of Mr.
Yes.
Sanchez, not
Yes.
the face.
so that's what he did. Now the question is whether the time of the shirt did, at the material time, when he was doing, thought that the man was going to be killed by the shirt, or he just did it on impulsion because he was asked, and he did it and walked out. But his now contention has been all throughout that he never intended to kill the man. The tying of shirt came from the other party, and he just impulsively did it. So that's his facts he relies on.
If you block both the mouth and the nose of an individual, so that you apply pressure over both the mouth and the nose, would that be strong evidence of an intention to kill that individual? For instance, if you put a pillow over somebody's face and held the pillow in place, would that be a strong evidence of an intention to kill?
No, my lord, on this point, there is a dispute.
And I appreciate that, but before getting on to the confusion that might have arisen, do you consider that would be a strong evidence of an intention to kill?
Again, my lord, it depends about the tying of the tape on the mouth.
Well, just answer my lord's question. It's quite important.
No,
if
but
you block somebody's mouth and nose, is that strong evidence of an intention to kill them?
no,
No?
no.
Really? If you
That's
block
what
their nose and mouth?
I'm trying to explain that, my lady. It's a good question. It's a question which also involves subjective or objective reasoning. Now, if somebody puts in this particular case, the shirt around the nose and the mouth, and you tie it, it won't.
It won't, what, sorry?
Won't kill somebody. It will not kill somebody, my lord. That's for sure.
Yeah.
It cannot. Because if you look at all the people wearing burqa, going all this tie around face, nose, mouth, it doesn't kill. It may impede him from having sufficient breathing. Maybe not the wholly, maybe there was some impedings of air pressure, that could be. But killing
the appellant was aware that paper had been stuffed into the victim's mouth and his mouth had been sealed with sellotape.
My lords, what he said...
And also there was some evidence of a broken nose.
My lords, what he said, he saw a piece of paper or two come out of the mouth, over the tape was over, and the paper had come out. But if that was the case, he would not know what amount of paper. He only said that a piece of paper to him came out, or he saw it.
I think he says there were papers protruding from his mouth.
Yes.
And he says, I saw tape. His
Yes,
mouth had already been tied with tape.
Yes, my lady, but that piece of paper, he wouldn't know how much paper was rusted. Secondly, when we talk about the nose, we have to look at the scene very carefully, and probably we have to apply a degree of subjective reasoning, because when we are saying that he coming with his bags of money, and the fraction of seconds had been told what to do, and he was doing that, how much did he observe about his nose being broken or being swollen, or how much is very difficult to say. But the whole point is that he did the tying of the shirt purely because he'd been told, and he didn't think much about it.
Well, how do we know that?
Yes, we don't know. But
How do we know that he didn't think much about it?
No, my lord, I accept that. But what I'm trying to say, given the kind of speed he's involved, the action he's taking the money, he's running out of it. Somebody.
Where does he say he's running?
Well, he may be speeding up because anybody got the loot.
Where does he say he's speeding up?
But he hasn't said so, but we have to imply, my lord. You have nothing else but to imply. When a person got all the loot, what do? You don't linger about. That's the basic. But it's a matter for you, my lords, to think. What would you do in that instance?
Just going back to the nose, he doesn't say that he saw that Mr. Largesse's nose had been broken. He doesn't mention his nose, does he?
No, he doesn't. Neither did he say the nose was covered. This come up in court.
We know that.
Yes.
But what he did say in his statement was that when he went to tie the shirt around Mr. Largesse's back and mouth, Mr. Largesse was face down, bound hand and foot, weighted down with heavy bags, and there was much blood on the floor near the head of Mr. Largesse.
Yes, my lord. That's what he saw, and that's what he said.
Yeah. So whether he knew that the nose was broken or not, he knew that something had happened to Mr. Legesse to cause there to be much blood on the floor by his head.
Well, that we can assume whatever we want to, my lord, on this. But basically, this is what he said.
And he adds, while I was tying his mouth with my shirt, blood got on my hands.
Yes, my lord.
Which may be thought to suggest that there was blood in the vicinity of the mouth.
That is quite admitted, because this is what he said.
Thank you.
My lords, having said this, now there's another point, obviously, the board has noted very well about the nose was never involved, came up in court. But there was another very important point that had been taken by the court, which obviously there was no proper evidence. He said that whilst he was tying the shirt, the head of the victim had moved. Your Lordship would have noted that. And that
he doesn't say the head. He says, while I was tying the mouth of Mr. Legesse, I knew that he was still alive as he was moving.
Yes, that's what I'm trying to say. He was moving his head. He said he moved, but obviously on that point, my lords, my research on this matter, if Your Lordship will approve that, I got an article on that point. If I may, I could not do that before. I couldn't get anything to assist you, that a person when he dies, they can...
Are you seeking now to introduce expert evidence
No,
in relation to medical matter?
No, I don't say expert. I said I was trying to find some expert report. I couldn't find any. But I do have some article.
We're not going to be assisted.
No, that's
Mr. Ramdoon, we're not going to be assisted by that.
That's okay, my lord. I'm in your hand. But I just said I did some research looking into it. So, what the position could be of a victim when he died after so many minutes, what happened, how movement arise from a dead person. That's all. If Your Lordship is not happy to have any new material, I'm in your hand.
I make clear that we're not going to be assisted by that.
Yes, okay. My lord, now looking at basically now the intent, in my submission, on the intent point, a person who is coming with his bags of money and has been asked to tie the face of the victim, there could not have been the kind of time required to think why he should tie his face. I personally, in my submission...
Nobody asked him to tie his face. They asked him to tie his mouth. Could that be to do with screaming?
Yes.
Calling out?
His mouth. So his mouth, he did it impulsively because he'd been told to do it. There could not have been a moment to think that that piece of shirt can be tied and that could kill or intend that this person would die. In my submission, is not possible. The circumstances of the facts is so strong in his favor that there could not have been any intention.
Well, he does say, I passed my shirt around his mouth and I tightened it with its two sleeves.
Yes, my lady, but also we see that word tighten, he used that word.
Yeah.
But was it tightened? In my submission, it wasn't, because those who came to the scene, they found it just decided it was loose. They said it was loose.
It was loose after they removed it from his face.
Sorry, my lord?
It was loose after they had removed it from his mouth?
Well, I do not think, my lord.
Then take us to the actual statement or the evidence where it establishes that the first person who comes to this body finds that the shirt is loose as opposed to tight.
Yes.
Where is that?
Because
Was it Mr. Salaby who came and Mr. Nuchitram?
yes,
Were they the first two officers
Yes.
on the scene? Mr. Salaby had an agreed statement read, page 1408. I don't think it says anything about the tightness of the shirt.
Yeah, just 1 second. Yes, so it's just a language. My lord, as you know, it was just pulled down to the neck because this is a language used here.
When you use the word just, where does that come from? You can pull down something that is tight, or you can pull down something that's loose.
Well, my lord.
Where do you get the description?
Yeah, I'm getting it to that where what exactly was said. But I just want to explain this, my lord, that the word that was used was pulled down, and it was later explained that it was loose. So I'm just trying to get that part.
Right. Well, we'll wait while you find that.
Sorry, my lord?
We will wait for you to find that.
Yes.
May I assist, my lord?
Yes.
There is the evidence of Officer Parsad, who explained that the shirt was lowered from the mouth at page 658.
So the hearing.
Thank you.
The hearing bundle?
Yes. Now, my lord, you've got page 658, as said, of the record is the e-bundle.
Record.
You have the very first line, A.
658 must be 658 of the record.
Record, yes.
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 Thank you.
But he was not the first person there. Mr. Salaby was the first person there.
Yes.
Yeah.
They lower, that's, I don't think this is disputed, my lady, so they lowered the shirt, which was on the mouth of the victim. So that's what has been said.
So that's what Parsad was told.
Yes.
And the they is Mr. Salaby and Mr. Naturam. I might have pronounced that wrong. And we've got a record of what Mr. Salaby says because his evidence was agreed. And he doesn't say anything about whether it was loose or tight or anything.
You say it was tight.
1408.
Yeah, that was used by the, what he understood, there was Dr. Gangadin.
Sorry, can you just show us before we... 1408, this is Officer Salaby.
Mr. Salabi is at page 82 of the record.
Sorry, what?
82 of the record.
Yeah.
1808.
Yes.
And Inspector Nachitram is at page 603 of the record, my lady and my lord.
He says there was, Mr. Salaby says at page 82, it describes the scene when he entered the vault. The hands and feet were tied behind the back with transparent sellotape, width of about 3 inches. The mouth and head were also tied with sellotape. There was also a long sleeve shirt which was tied to his mouth. Describes the bags on the victim's legs.
Could you please give me the page reference again for Inspector Maturin's evidence? I thought you said 643, but that...
So it's 603.
603, my lord.
603?
Yeah.
Oh, I'm so sorry, I thought it said 643. 603, thank you. Right, thank you.
Top of the page, his mouth was tied with a cloth which was blue and there were white stripes on it.
Yes.
So is it fair to say there was no evidence about how tight or otherwise the shirt was?
No.
Apart from the appellant's own evidence where he says that he tied it tight.
Yes, but
Tightened it with its 2 sleeves. That's what he says.
But my lady, Rhodes, on this point, we have to think very carefully, subjectively, and make some inferences. A cloth, a shirt. When you tie it 1 knot, how much strength can there be in a knot and stay there? In my submission, it will have very little effect, if at all. Yes, my lords. The question now arising on this is obviously the intention and the effect, the act itself, what effect it had. My submission on the intention, there could not have been any intention. Regarding the act, one can look at basically tying a shirt 1 knot. What effect can it have in a man or in a person? The act itself is circumstantially looking at, considering the circumstance of the act, it cannot be such that one could say that it has injured the person. In my submission, again, the act per se.
But there was expert evidence of its effect.
Sorry, my lord?
There was expert evidence from Dr. Gungadin of what its effect would be.
Well, my lord, with due respect, he was giving a guesswork. He said that, logically speaking, this is what will happen. But that in itself does not have any kind of validity as such, my lord, because we have to consider this man in his laboratory never considered the effect of the shirt. This came about in the court, in the trial, where he was asked, what is the effect of the shirt? And he said, logically speaking, this may happen. We hold the tape. How can it hold a tape which was put round the mouth 3-4 times? How can that be of effect? So in itself, that report was basically not a forensic report. It was just an idea given to the court based on prompted questions. There was no medical...
Well, couldn't you then have applied, as I understand it, there wasn't any written report prior to the trial starting to the effect that the shirt would have also contributed towards the death. This emerged at the trial, that it was a contributory factor because it put more pressure on the paper stuffed into the mouth, right back down to the throat. And if you were taken by surprise by that, couldn't you have applied to adjourn?
My Lord, I cannot speak for those defending at the time and what was happening. But it is very clear, one has to understand the fact that the mouth was tied with so many rounds of tape, 3 inches wide, and that would have been such that no material over the tape could have had any effect whatsoever.
Well, that was
So,
not,
my
that,
Lord,
that was not the evidence of Dr. Gangadhar.
My Lord, the question is not what evidence we have. If the evidence was not there, my Lord, the board is wise enough to understand, regardless of what was there or not there, when it comes to justice, a human life, one has to see exactly what can be inferred. Right, wrong is a matter of individual thinking properly in the circumstances what could have happened.
Well, just looking at the report he prepared before the trial,
Yes, my lady.
which is in the hearing bundle on 1757,
Yes,
he records on external examination that the shirt was around the neck.
yes,
So he didn't see the shirt around the mouth. What he saw was multiple turns of adhesive tapes around the mouth,
yes,
and that the mouth was stuffed with papers.
yes. That's correct.
Could I ask you about another matter, and that is that the blood is on the floor, isn't it, around the face of the victim? Yeah, there was much blood on the floor near the head of Mr. Legesse. In the event, what other injuries to the head or the face had Mr. Legesse suffered, apart from a broken nose, that could potentially have caused such a large volume of blood on the floor?
My Lord, I cannot say. I don't have any expertise on this.
What does the autopsy report say? Is there any other injury? I'm just imagining somebody tying a shirt around the mouth of the victim, seeing a huge amount of blood, and presumably seeing that blood around the nose of the victim.
That may be so, my Lord, but I can't vouch for a matter of this nature. But
if at some stage, if you could just, on the basis of the autopsy report, indicate whether there was any other injury.
There was a laceration to his left eye, split tears to the right side of his lower lip. That's 1757. One of his tooth was fractured. Whether that caused bleeding.
My Lord, if that could be any help, page 1757, and we have a list of injuries, and you say under external examination, that may be a cause to have allowed blood to come out. That could be so.
But Mr. Ramdan, although it's not an attractive image to look at, on page 1687 or 361, we see, don't we, the distribution of the blood on the face after removal of sellotape and shirt. There's plainly a mass of blood emanating from the nose.
Yes, yes, my lord. But obviously that is a matter which was seen by the medical experts. And at what we're talking about, the appellant, at the material time, what has happened, what he did, because he clearly said beyond those, he didn't know. So what we're saying here is not going to help appellant or help us to explain, other than seeing what we have seen. We admit there's no problem with this.
Just put it bluntly to you, if you see a person whose nose is pouring blood or has poured blood out and is compromised, so breathing through the nose is compromised, and then you make his breathing through his mouth even worse, would that be evidence of an intention to kill?
My lord, no. I say this because at the time he was tying the shirt, he was just under an instruction, acting, as I said, he wanted to get out of the place, he was told to tie it, and one has to see if you intend to kill. Will tying a shirt of that nature, a shirt which is a summer shirt used in Mauritius in the month of February, which is always very hot, you tie that, that could not have an effect in mind that you're killing the person or you're trying to kill him. One could simply, the simple explanation could be in the mind of the appellant was that he was asked to do a tying, he did. But whether he stopped to think he was killing a person, no, my lord. Yes, my lords. Now, the only other factor is, because in my submissions, there is no act per se, which looking at all the circumstances of the fact as it is, that could have an act which lead to death at any degree on the facts that prevailed. And as far as what he could have seen, what he had seen, etc., in my submission, he could not have thought of killing the man. Thus, so far goes to the act itself. As we discussed the intention, the way it happened couldn't. The only element we have to see whether there was a premeditation. Now, has been said that he premeditated and was used that a plan made. The plan was basically a plan to rob. And that's been brought forward, used in the scenario, in the situation, to say he premeditated. In my submission, there could not have been any moment of time to think and plan to kill a person. There could not have been a premeditation. It could not have existed at that moment, at the time he was doing that time search. None of this element could have existed. Unless your lordship think that it could be of help any further.
The judge described two scenarios for
Yes.
premeditation, didn't he? Do you want to deal with those two scenarios?
Yes.
And what the evidence was for them?
Yes, Maria, could you show that too? The two scenarios.
It's at page 284 of the record.
Yes, so my lady, we are looking at paragraph 25, scenario 1. The most obvious scenario of premeditation suggests the idea that quite some time before the act of killing, the accused thought about about a way of killing the victim, and later he carries out the plan. That's the scenario 1, he says. But that is a scenario. Whether in the circumstances, what the facts happen, what prevailed, there's none of them existing, whether the mind or in the action. He just put a scenario. But the scenario, how do you relate that scenario to what really happened? I cannot say it. To me, scenario 1 is hypothetical. Then we have the second scenario. You will realize that very often a killing can take place in the heat of a moment. Now the question is he talking of a scenario which is dealing with the appellant's case or a general scenario? In my submission, it does not relate to the scenario of our client, because there is no question of a heat of a moment.
Well, he then goes on, doesn't he?
Yes.
To deal with each of those.
Yeah, he says, this refers to an accident that takes place over quite a short period, and which leads to death of the victim.
And then at line 20 on 285, he deals with the first scenario, and over the page, he talks about the plan, all part of the first scenario, and then on 287, he talks about the second scenario.
Yeah. But none of this, my lady, with due respect, does not really link the act in the mind or whatever at that moment. Circumstances were such, and none of this existed. He presumed it. He made a kind of factual situation, environment that could have happened. But per se, there was nothing that could be said that happened.
Are you saying there was no evidence to support it?
No, there was, my lady.
Could you help me with this, please, Mr. Ramdan? On page 286 of the record, line 5, the judge quotes from the Creole statement of the appellant, talking about a plan pour attaque. Could you help us with your translation of a plan pour attaque?
Yes, my lord. The plan that they had before coming to the robbery, that they had to attack the person. For them, attack in our language, I would suggest, I would think, it means to sort of do an act which can frighten somebody or hold somebody, but not attack in the sense that was taken here. That means killing. Attack here in our sense, in English language, as I think, we don't have an exact translation, but attack simply means to frighten somebody, to hold them, to do whatever is necessary to probably stop them from doing any act. So that's what they understood. Or probably have a knife against them, or a gun against them, to frighten them, to hold them in fear. So having to hold somebody in fear, or whether it means to kill, in my submission, no.
Thank you.
Yes. Now, the other matter, basically, my lord, so unless your lordship has any question about the mind, the intention, or...
Yes, you can help me on one thing, perhaps, and that is that it's now accepted, I think, that there was no evidence that the shirt had been tied around the nose of Mr. Lagesse.
Yes, my lord.
However, during the evidence of the expert, Dr. Gangadin, the judge asked a question which was based on the assumption that the shirt was tied over the mouth and the nose.
Yes, yes, my lord.
Which was not an accurate premise.
Correct, my lord.
When it came to this, and Dr. Gangadin answered the question on that basis. When it came to the summing up, the judge did not tell the jury that there was any evidence that the shirt had been tied around the nose, but he did, and it's at page 280 of the record, recite the question and answer, question he'd put to Dr. Gangadin, and the answer, which was on the basis that the shirt had been tied around the nose as well as the mouth.
Yes.
What do you want to say about that?
Well, what I can say, my lord, when we say that he, in his summing up, he did not say or made mention of the nose and mouth together, that's not really relevant in a criminal act, in a criminal hearing, because the whole situation is a jury. When you lead questions, when you say something to the jurors, one has to understand what impact was he creating by saying questions, asking. So in my submission, by asking a question which was very hypothetical, did not exist, the fact wasn't there, he used it to somehow affect the jury's mind. The juries took it differently. We would not know.
Perhaps we should just look at page 280 of the record.
Yes, particular line, my lord.
I'm just getting the document up on the screen. It's page 280.
Line 22.
Thank you. But before that, the judge does say at line 15, the statement of the accused, where the following is said, and I'm going to quote you verbatim what he said, and then he then sets it out in Creole. which the accused said that he'd attached it to the mouth or put it over the mouth. Le ton motif attache la bouche.
Yes.
And then the judge went on to say, that's what the accused said. Now you will also refer to the evidence of Dr. Gangadin. And in this connection, I'm going to read to you an extract of the court record from the transcript. It's exactly word for word what Dr. Gangadin said in court. It was put the following question: from the moment the mouth and nose are tied with a shirt, how long would you say this person would have taken to pass away, in view of what you said, that probably the shirt would have interfered even more with the breathing process? Your opinion, doctor? And the doctor answered this: 3 to 4 minutes would be more than enough for that person to die. The question was then asked again: we're talking from the moment the shirt is tied, and the answer of the doctor was maybe lesser or so, but not more than this.
My Lord, as you can see here, a scenario was pictured which didn't exist. What the Dr. Gangadin has been doing, he's gone outside his report, because this shirt tying on the mouth, he has not analyzed it at all, nor did he have any effect, any report made on it. Now, the judge is asking about the 3 minutes and 4 minutes about tying the shirt before, after. Again, your Lordship will see that the explanation the report gives that this man, after the paper was thrusted in his throat, would have died anyway within 3 or 4 minutes. But then here, the judge is fishing for some other explanation. And that is, if the paper is still there, how many minutes will take? The guy repeats, 3 to 4 minutes. So basically, what has happened here, it was convoluted, confusing, and I do not think in my submission.
The question relates to the time from which the shirt was tied.
Yes, that's what I'm trying to explain. The report said 3 to 4 minutes.
But it's about the nose.
My lady, we come back to the nose. So the nose is not involved.
He's telling the jury.
Yes, I know. This is my submission.
What do you say about that?
What impact does that have? There are two crucial issues: intention and premeditation.
Yes.
What potential impact does it have on the jury if you tell the jury that both the mouth and the nose were obscured by the shirt?
My Lord, if one is to take it subjectively, it would have a serious impact. I would think that this man, the appellant, is guilty and he did what he did was wrong. The impact would be very serious. But I am trying to simply explain in my submission that this language, the way it has been used, is convoluted, confusing, and very wrong to the jury. That's all I'm trying to say, because this scenario did not happen. The nose and mouth did not happen. So he has brought it out to the jury.
Well, the mouth did, but the nose did not.
Mouth, okay, I understand the mouth, but when you put mouth and the nose, that makes it more serious, if there was any seriousness. If mouth was serious.
More serious in relation to what issue?
To the killing.
To what issue in the killing?
My Lord, we are talking about the mouth and nose having the cloth. What effect?
Is that in relation to causation, or is that in relation to intention, or what's it in relation to?
Well, my Lord, in my submission, there is neither causation or no intention, because you would know, logically speaking, as a human being, if you put a shirt, try it, my Lord, you will see, put a shirt around your nose and mouth, it doesn't have an effect.
Oh, I don't agree with you.
But if the court in the trial was trying to make an effect...
More importantly, the expert evidence wasn't to that effect.
Expert hasn't said anything on this, my Lord. I have not analyzed it the expert did say about simply that about the shirt, it was pulled down, it was loose, it was around the neck, but he didn't go into say if it was on the mouth, as his colleague had told him, and this is a effect. Scientifically, forensically, it would have.
Well, he did say that in answer to questions in evidence. He may not have said it in his report.
My lady
he said it in evidence.
My lady, with due respect, yes, he said it purport like a general person. He said logically, I'm saying it. He used the word logically. So are we using logic or are we using forensic?
Well, it's page 714 in particular, I think. At the top of the page.
What line, my lord?
So he says the effect of the shirt is that it prevents the gag coming out further. It will affect more pressure on the gag, i.e. those papers would further enter in his throat, and if there would have been a chance the paper to come out, it would not come out at all, i.e. it worsens the situation a bit more. And defence counsel is given an opportunity to ask questions thereafter, as we see just below line 20. That's correct, isn't it?
My lord, the question, if one look at it very carefully and analyze it, this question has a reason prompted to probably help whether the shirt has an effect. But if your lordship will have to consider very carefully the act prior to the shirt, having the tape few rounds, the shirt could not have any effect. So that was prompted probably to say that that shirt would put pressure on the tape. But the tape itself, when you put it round, it has sealed the mouth and the whole thing. There wouldn't have any room for any further pressure to be put by a shirt.
So it's your submission that the question and answer related by the judge in the summing up, which proceeded on the basis that both the nose and the mouth have been covered, have a bearing on causation and also on intention to kill. Is that right?
Yeah, there's no bearing whatsoever, Your Honor. The whole question raised by the court on the shirt, there's no effect, and they would not have anything to do with the killing.
Do you have any further submissions to make in relation to these matters of intention and premeditation, causation?
Well, no, my lord, I have already said. My lord, my colleague just wanted me to draw your attention on 714, the way it was a question, if there was no shirt, there was, how we call it, there was paper, as you explained, up to the throat, there was sellotape.
Sorry,
with
714, forgive me, we're on page 714.
Yeah, 714.
What's the point you're making?
Just a point, my lord, for your consideration, line 22, where it says, if there was no shirt, there was, how we call it, there was paper, as you explained, up to the throat, there was sellotape. Would that person survive? And the answer, maybe not. So
he would have died.
He would have any event. In any event, he would die. So,
yeah.
So that's. But my point again, now coming back to it, my submission, my lord, on this point is that shirt has no effect. However way we look at it, it could not have an effect. Given the circumstances, given the tape, everything that was, it would not have any effect. That is on intention. Whether causation equally, whether it cannot cause, a shirt could not have caused any causation leading to death. There's nothing substantial, evidential can be shown or proven by having a shirt over the tail that would have caused the death. So there couldn't be any such causation.
Mr. Ramdan, I understand your submission, of course, but just looking at the top of page 714, the evidence of the doctor in the first 10 lines, which was not challenged at trial, was it not open to the jury to accept that evidence as establishing that the tying of the shirt contributed to the death by accelerating it, bringing it forward in time?
My Lord, I take that point. If it was not challenged, obviously the jury may think that way, because one has to understand that the jury could not have had such ability and knowledge to understand how the whole gagging was and how efficient was the gagging. They wouldn't have taken all this. In particular, the way the court brought in the nose and the mouth, the tying of the shirt, it would have influenced the jury to the core. And the jury could not think otherwise.
I couldn't ask you a question about page 288 of the record, which is the judge's summing up to the jury, and it's in relation to the issue of premeditation.
Yes.
And the judge directs the jury that the accused then seems to have acted calmly in removing his shirt and carrying out the act of tying the mouth of the deceased, which act appears to be uncalled for in the circumstances suggested earlier. And I was wondering what evidence there was to have led the judge to state that the accused acted calmly, as opposing to leaving that issue for the jury to decide. That is, here are the factors that would indicate that the accused acted calmly, and here are the factors you might later take into account in deciding whether the accused wasn't acting calmly. And particularly when one considers that the full extent of the injuries or the blood around the nose and the face may not have been fully apparent to the accused until he starts tying his shirt. And so the premeditation might be formed at any stage during that process of coming from the back of the room to the front of the room. But anyway, I'd be grateful for your submissions about that direction from the judge.
My Lord, to start with, the word calmly and coolly is a word which is very complex in itself for a legal purpose. It is not something one can say from outside when it is a subjective point, what the person inside is thinking. But objectively, we can make a deduction, an inference as to what can be coolly and calmly. My Lord, if looking at this point, calmly, what does that mean? What does it connote? Given the circumstances, man is carrying his 3 bags of money, loot, God told him to do something, and he done it and walk out. Now the question is, how can we say, as an observer, was he acting calmly, coolly? What do we think in his mind going? If I ask my opinion, my lords, a mind will not be subjected to any of those. My mind was subjected in how I get out with my loot. My mind was more tied to that thinking than any other thinking. So the acting of coolly and calmly, maybe outside this kind of subjective view, would be to think, have time to sit down and think what I'm going to do, how I'm going to do it.
So are you saying the evidence was as consistent with this being chaotic and...
Sorry, my lady.
Are you saying the evidence was as consistent with it all being chaotic and the very opposite of calm as being calm?
Yeah, it is opposite to calm. Yes, my lady, yes.
Do you have any criticism to make of the judge's directions on this issue relating to calmness, legal directions?
My Lord, having considered very carefully what the judge was saying, in my submission he was wrong. He did not describe the calmly in the context. He has explained the calmly and coolly generally by looking at Dalloz, looking at the French authorities and whatnot. He has that, but he did not in particular got his mind to think what was happening, what the man did. Was he acting coolly, calmly? I think he gave that a general description, not a specific one.
Right, but as a general description, you don't criticise what he said about the law.
Well, generally what he says the law, I have no qualm about it, my Lord.
Yes, thank you.
Yeah, my Lord, unless you have...
What other submissions do you have?
Sorry, my Lord?
What other submissions do you have?
My submission was generally to get a picture, besides the three elements of the intention, premeditation, but generally one has to look at the cases overall, what has happened, what not. If your Lordship will allow me, I can go beyond the three elements we're talking about on a general view, a general picture of the facts.
Yes.
Because that's simply to give you an understanding how things has happened besides these three elements.
Well, you have other grounds of appeal and other submissions to make, no doubt, in relation to those grounds of appeal. It's a matter for you as to how you proceed. We are familiar with the factual background of the case, however.
Yes. But if your Lordship wants me in a particular issue that you want me to hear because of a time constraint, I'm happy to go in the particular one.
No, you must use your time as you see fit, but there are, no doubt you'll want to develop your other grounds.
So in that event, my Lord, let me come back to the issues what we have pleaded. The first one would be basically issue A. Can you give the page of issue A?
Yes.
Yes, that would be.
Well, they're listed at page 42 of the key documents bundle. It's paragraph 28 of your case.
Page 4, my Lord, 44.
Yeah.
Issue A, whether the victim had already died
Yes.
at the time the appellant was tying his shirt around the mouth of the victim.
Yes. My Lord, I was going to probably just expand this to explain the time that took for the man the appellant, to do his act, picking up the loot, the time, really, how much time he could have taken.
Don't you have a real difficulty because of his own evidence that he saw Mr. Largesse moving?
No,
Okay.
my lady, I don't have that.
Okay.
Well, it's a matter for the jury. They had that evidence. They can form the opinion that he was still alive based upon your client's own evidence.
My Lord, that is a view generally we take. Whether the jury had that ability, capacity, we don't degrade them, we don't think higher or lower, but when you have certain facts, which is complicated.
The jury weigh those facts, and they weigh the arguments that you make about the timing and so on. And they have, on the other hand, your client's own statement that when he was tying the shirt round the mouth, the victim was alive, was moving.
Yes, my lords. I don't dispute that. I think it was not disputed because the expert didn't explain this. But the point that we have to consider whether the movement was such that it was a matter which was probably wrong in the way the appellant thought. The appellant thought that the man was alive.
Well, he could have given evidence and said, I made a mistake.
No, the appellant
just moved and I didn't think he was alive.
The appellant did say he saw the body moving, the head moving. There is no dispute.
He said he was alive.
Yes, yes, my lord. But I am submitting that looking at the facts of the case, looking at the time what was doing, who did what, it is not possible based on the medical report that this man was alive. And this is what I try my best to see if I could assist the board with some kind of article, some kind of evidence, but...
Well, we've dealt with that.
I mean, there are some issues that are fought out at a first instance trial, and all the arguments are laid out, and the jury select one piece of evidence, which is pretty strong evidence, that your client says, I knew that he was still alive as he was moving.
Yes, my lord. I have no difficulties in that.
The jury made up their minds about the issue.
Yes, but my lord, I do take this, but this board is here to see whether that evidence that was produced is an evidence which can be substantiated based on what we have, generally observing it from a different angle. And different angle is a board. The board is here. We can see if subjectively you're taking it very strongly. After considering everything, you come to the same conclusion as a jury. I have no problem. But I just put this...
But it's not our function to decide the case. The jury decide the case. It's our function to see whether they have evidence to support their conclusion.
My lord, that is true. That's why I was trying to say when we calculate the time, the amount of time that was doing A, B, C, D, and based on what action took place, what would have happened really if taken very seriously, very carefully. That's my submission on this point. But if your lordship is happy with what has happened, you consider that there is no need to hear further, I am in your hand.
Right. Well, your submission on ground A, as I understand it, is that because of the evidence of Dr. Gangadin, it would not be possible for the victim to have been alive at the time the shirt was tied around his mouth, and therefore that would destroy the causation. That's your point?
Yes.
Yes. Thank you.
Yes. So could we move into the submission, which is
it's paragraph 28 of your written case.
Yeah, I've got submission issue B, the manner in which the shirt was tied, and then again, my lord, this is very brief to say that the manner, the way it was done, the kind of shirt it was, and given one knot, in my submission, it cannot have any effect whatsoever. And above all, the manner matters. The manner matters because the manner shows whether a person in what he was doing at that particular time, could he have thought of killing or not killing, thinking, whatever. In my submission, the manner in which it was done, it was very sort of impulsive, do it because somebody said it, and walk on. That's my submission on this one.
Thank you.
Now, the other, we have dealt with issue C, which is a mens rea and all this, my lord. I don't think you would need to know anything from me, which I can't give you more than what we discussed. But we have the issue D.
Yes.
Whether, given the circumstances of the case, whether prosecution was wrong in not having all the co-accused, including the accused who masterminded the case. My lord, this is, in my submission, is a very important factor. Whether the prosecution had a discretion or not, given that a man was killed, and so violently, and they were to be accepted, agreed upon being a charge of manslaughter.
Forgive me, the two accomplices who entered the vault with the appellant pleaded guilty to manslaughter?
That's correct. That's what I understand.
Yes.
But
Was anybody else prosecuted in respect of this?
Except no, my lord. The appellant was given the chance, as I understand it, given the chance to plead manslaughter.
He was given the chance.
Yes, and he refused.
Yeah.
And my lord and lady, the reason being that
Well, do we need to hear about the reason?
We don't need
can't
to.
get evidence.
We can't hear that. We can't hear that. But he was given the chance to plead guilty to manslaughter, and that didn't happen. So nobody else was prosecuted. He was the only person who was tried in respect of this robbery.
yes, he was the only person tried, my lord. See?
But in those circumstances, there could not have been a joint trial.
Oh, my lord, I understand. Venison, who I call mastermind, was tried separately.
Right.
Oh, he was.
That's all I understand. I'm sorry, my lord, I didn't have that. He was tried separately. Yes, yes.
Was he just charged with robbery, or was he also charged with murder?
He was charged with I think, my lord, if you were to refer to page, is that page 86? On the? Of our case.
Page?
Page 86.
That's not venison, that's the two.
Yeah. What is it you want to take us to?
Sorry, my lord?
Mr. Ramden, what document do you want to take us to?
We just, the question trying to answer about whether anybody else was
Yes.
tried. So
Was Mr. Venison prosecuted for murder, or was he prosecuted for robbery?
No, I've got here, if we look at the charges, which is paragraph 3, under the name of Puveden, it says they also called venison. If you look at the count 3, my lords, page 86.
Also called venison, I see.
Yes. Then messenger, etc.
Aid and abet.
Yes.
Aid and abet what?
Yes.
But he was charged with aiding and abetting theft of the money.
Yes.
And in count 4, Venison was also charged with what looks like handling stolen goods, in effect, namely his share of the proceeds.
Yes.
Right. So your point is, as I understand it, that this appellant before us should have been tried jointly with Mr. Venison?
With all of them, my lord, those who are joined in the
That nobody else was prosecuted. There was no trial because the other two who entered the vault pleaded guilty.
The other two pleaded guilty. So my case in this is, my lord, that the reason they should have been jointly tried all together who are involved in the matter was because if the truth is to be found, that was the only way to find the truth of the case.
How can you have a trial of a defendant who pleads guilty?
My lord, this is where my submission is, when you accept guilty plea, we have to accept to see whether fairness will prevail afterwards. A consequence has to be understood because it's very easy for prosecution to say, look, two of you pleading guilty, fine, this is what I agree, I accept. The other one, go to trial.
So are you saying that the prosecution should not have accepted the guilty pleas?
On the rest of, no, my lord. My submission is the prosecution to have fairness, a proper trial where truth could have been found against the appellant. To find the truth, there was only one way.
And what should have happened? What do you say?
What would have happened, my lords? The truth would have come out as to who did what exactly happened, and
yes, but your criticism is that the appellant was not tried jointly with other defendants.
yes.
How could that have happened?
My lord, my submission to the board is that if all of them were tried together, instead of separating them, accepting guilt, etc., justice would not come out, because if all of the three or four...
I understand your submission. Your submission, in short, is that the prosecution should have refused to accept guilty pleas.
Yes.
Yes.
And accordingly, that those individuals should have been deprived of their right to plead guilty.
Yes.
And the trial should therefore have proceeded against everyone.
Yes.
Well, I put that a moment ago, and was told it wasn't the case.
Yes, but the point of the reason behind it, my lord, because if justice is to prevail,
I wonder, is any authority for this proposition?
my lord, the question is the authority. The board can be the authority looking at the facts.
Yeah.
If your lordship think that it's not
I think we've got your submission in relation to issue D.
Thank you.
Can we move on to E, please?
Now, my lords, regarding the experts' evidence in details, this one is quite important. One has to go through the facts of the case and the experts' evidence, and that would be found at page 1997, my lords and lady.
Well, there are two limbs to this, Mr. Ramdoon. One is whether the evidence was properly interpreted by the court. That's a matter for the jury, isn't it?
Well, my lord, partially yes, but again, on the other hand, jury has to be explained sometime where there is a confusion. In particular, in this case, there was a convolution, there was a confusion, there was many things that happened. It was a judge's duty to ensure that the jury fully understand and explicitly understand all the points what has happened.
So are you saying that the judge misrepresented the evidence of Dr. Gangadin?
Well, my submission on this is, my lord, is if a judge is asking question outside the facts or something that didn't happen and answers were given, whether those answers could have an effect in the mind of the jury.
I understand. And this comes back perhaps to your submission that you've already made in relation to the question put to Dr. Gangadin on the basis of the shirt having been tied around the nose as well as around the mouth.
That's correct.
And is that essentially the point you make here?
Well, that's correct, my lord. But also, what is also most important, besides the nose and the mouth, jury are ordinary people of the street, and they're very much subjected to how a judge explains the case, because a judge stands like a very powerful, acceptable person, and person of confidence, and a person who got to be trusted. And my view is that when a judge is doing what he's doing, which can mislead and misinterpret, is very crucial. And that's the point I was trying to raise with Gangadin being asked so many times, plus the way he was led about asking questions on answers, not giving the chance to the other side to raise matters, etc. He took over the prosecution and the questioning, cross-examining. All these mattered very much to affect the jury. That's my submission on this point.
Right, I see. Well, I can assist you by just saying that all the members of the board have read the evidence in chief and in cross-examination of Dr. Gangadin.
Yes, my lord. So I don't need to take further time on this, my lord.
Thank you. And then you see the other limb. Forgive me. The other limb is that you say that the witness was biased. Is there any evidence of that?
Which one, my lord? F?
Ground E.
D.
Whether the expert was completely biased. I mean, that's a serious allegation to make.
So, my lord, did you refer to issue D?
No, issue E.
Issue E, yes.
Whether the evidence of the expert witness was properly interpreted by the court and whether the expert was completely biased.
Yes, my lord, on this point, whether the trial can be said to be fair, that's fair.
No, E.
See, I thought your attack was on the judge leading the expert witness, rather than the expert witness being a biased witness.
Yes. Yes, my lord, this particular issue, whether the evidence of the expert was properly interpreted by the court and whether the expert was completely biased, that's the point you're raising.
Yes.
Yes. My lord, I would say this on this point, my lord, is not an attack, but if, as you have read the questions asked and the way he answered it, you will see that, for example, start by, I'm not asking you about mouth, but I'm asking questions specifically about nose. When it went further down, you would see, as you've said you've read, that the expert gave way and started answering as if to please the court. And to me, if there isn't any place where he said, but he should, on my submission, say to the court, to the judge, look, I have done my report on the basis of the mouth. Anything further beyond, I can only give an opinion, but that opinion is based on no evidence whatsoever other than what I said. But he never said it. My case on this point is simply that the expert should have clarified generally. So the jury...
So that's essentially the point.
Yes.
And it comes back to the question about the nose and the mouth again.
Yes, my lord, that's... yes,
I understand, thank you.
Yes.
I understand.
Yes.
Thank you.
But on that point, my lord, with due respect, I am simply trying to say what effect it was having on the jury. That's my point.
So we have that submission. Issue F. already addressed us on the manner in which the judge questioned the expert witness, Dr. Gangadin.
Yes, yes, my lord. The matter is the frequent intervention and conduct of the judge. We have it at page 2060 to 2095. And what has happened is at annexure, there was an additional part added in the bundle, is in your e-bundle, is page 2096 to 2121. That's annexure 3. If you were to go into it, annexure 2 is...
So what's the page number again, please?
Yeah, there's 2096 to 2121. And then we have the other one was also annexure 2, 2060 to 2095. Now, generally, my lords, again, that has been clearly explained what had happened, and it's a matter, if you want me to go in details, I can, but I would suggest, in my submission, it would be left to your discussion on this.
Very well.
So the detailed points are set out in these appendices?
Yes, my lords.
Yes.
Yes. All those are put in details
Yes.
for your assistance.
Yeah, that's helpful.
Thank you.
And then we have G issue, whether in all the circumstances a judge misdirected the jury or failed to direct the jury on this. We have already discussed quite extensively on the tying of the shirt. We have discussed acting coolly and calmly. We have discussed other than this. So, well, the other matter that I can raise about we have discussed.
Can you help us, please, going back to F for a moment? The judge's failure to explain to the jury about being customers of the bank. I mean,
Yes.
that's a
Yes,
submission.
my lord, I could. My lord, what has happened in this particular case, as I understand it, initially the judge accepted that the counsel has a good point about the jurors, that those who were members of the bank which was robbed, that they should not be members of the jury.
When you say members, do you mean employees or do you mean
beg your
customers?
pardon, my lady, a customer.
Yes.
A customer, I'm sorry. So it was objected that customers should be a member of the jury. But when initially the point was accepted, agreed, taken, on the next, when the panel came about, then the judge dismissed that completely and told the counsel that he is going to take the panel as it comes.
And now, why was he wrong to do that?
Well, my lord, the reason why the counsel objected was because in Mauritius, as I take it, I understand it on my inquiry, that a customer, when they see that 51 million rupees is stolen, they might suffer. And they have gone through thinking that they would be affected or something could happen, whatever. I cannot say what exactly went in the mind, but the counsel at the time, after taking all the information, understood that a particular customer of the bank would be biased. And for that reason, he wanted not to have such a juror.
All right.
How much is 51 million rupees in dollars?
I think, my lord, it would be about £1 million of our currency.
There we are. We have your submission in relation to the judge's failure to inform the jury of their right to dissent.
Well, My Lord,
We have that submission, I think, don't we?
I do not think I have put it very clearly on this, because the whole idea of dissenting was this: what normally should have happened, the judge should have given a direction to the jury that should they reach a point that they cannot decide unanimously, to come back, and he would give further direction. Not having done so, there are members of the jury, they could have taken it, that means they have no choice. They should discuss among themselves, concluded unanimously. If I don't like it, I say yes, because I have to. So this was to be made very clear that they had a chance to say, I don't agree, and let the judge give the direction, but that was not done.
Well, we have that point. Thank you.
Now,
that clock's not working, in fact, Mr. Ramdun, so it may be appropriate that we,
yes, thank you, my
that
Lord.
we take an adjournment now, and we'll hear you at 2 o'clock on the remaining matters.
Thank you, my Lord.